It's an honor to be a part of this panel and to share the platform with so many of my colleagues whose perspectives I think will inform this discussion. Andrew has asked me to kick things off today by doing a little bit of framing. I'll actually be speaking again just a little bit later on college and university policy best practices, but the framing part of the conversation I hope will set the stage for the entire panel and the work environment in which we all operate. I have the privilege, I suppose it's a privilege, of working in a perfect storm environment, in the sense that sexual violence on college campuses is an important crossroads for political and cultural currents that are impacting even the presidential election as we speak, of course, and all of us are very well aware of that. But I think in many ways that colleges and universities are the crucible in which these issues play out perhaps more acutely than in any other venue of our society. And so I have worked now in the field for 18 years trying to impress upon colleges and universities and the K-12 world as well that Title IX is an important federal guideline for how we address behaviors like sexual violence and stalking and intimate partner violence, in addition to sexual harassment. And that has been something of an uphill battle for many years. I think that higher ed particularly was very slow to understand and then embrace the ways in which Title IX and other federal statutes like the Clery Act and Violence Against Women Act Section 304, the way that these laws impact on how colleges and universities are obligated to respond to sexual violence and other forms of sex and gender discrimination. And so it wasn't until the Department of Education decided in April of 2011 that it really needed to clarify these standards for all of higher education that the mood of the field shifted and began to understand better the ways in which Title IX played out and impacted on how the university should process and resolve and remedy sexual violence complaints. And in April of 2011, the Department of Education's Office for Civil Rights, I'll call them OCR, issued a Dear Colleague letter. And this Dear Colleague letter was a 19-page missive that really went into incredible depth compared to whatever guidance we'd had from OCR previously on what the expectations were, that colleges and universities needed to have a Title IX coordinator in place, that Title IX coordinator was more than just a person who was a liaison for government inquiries, but had a responsibility for oversight of the entire program within a college or university for Title IX compliance, that colleges and universities had an obligation to investigate and remedy sex discrimination when it came to light, and that sexual violence was certainly a type of sex discrimination that came within OCR's ambit. OCR also made very clear that it was starting a new enforcement initiative, one that really began in 2010. They announced it officially in 2011. That would hold colleges and universities accountable for inappropriate response, an unreasonable response to sexual violence when and if those allegations were made. To date, there have been 275 complaints, give or take, made since OCR announced its new enforcement initiative. And probably most controversially, OCR announced that across the entire country, colleges and schools would be obligated to use the preponderance of evidence standard to remedy sex and gender-based discrimination allegations and complaints. Most colleges were, in fact, already using the preponderance of evidence standard at the time, so it's not nearly as controversial or big a change as most people think. Despite that, there are many who believe that higher standards of evidence would be more appropriate to the quasi-criminal nature of sexual violence as it's addressed in discrimination form in the college and university environment. And so colleges began diligently, as of April of 2011, to try to implement this 19-page guidance. And in many ways, the letter raised more questions than it answered. And I think OCR realized that pretty quickly. They did a public solicitation of questions and told higher education that they would publish a set of FAQs, questions and answers, that would amplify on that Dear Colleague letter and clarify some of the things that were confusing. It took OCR until 2014 to do so, at which point they issued a 57-page letter to clarify the 19-page letter. And so you begin to see a cascade of sub-regulatory guidance from the Department of Education imposing more and more obligations on colleges and schools. At the same time, Congress went to work on what was at the time called the Campus Save Act, but when it was enacted as Section 304 of the Violence Against Women Amendments Act, and today is actually part of the Clery Act, which imposed 70 new requirements on colleges and universities in addition to everything that had been imposed by OCR since 2011. And that's sort of a little bit of what the regulatory front looked like. And if you were a college administrator at the time, I think you felt a little bit punch drunk, because as you understand, it wasn't like there were Title IX coordinators and civil rights investigators sitting in the wings in 2011 waiting for OCR to say go. Right? That was a capacity, a skill set, even a profession that had to be built within the field. And that capacity is still being built today. It doesn't exist at the level that it needs to. But who's going to carry out all of these instructions from OCR but those administrators who didn't exist in 2011? And then very quickly, that was compounded by the pressure that victims added by bringing complaints to the Department of Education. 275 to date. The Department of Education decided it would release publicly its resolution letters, holding colleges and universities accountable. And one of the major shifts that occurred was that the Department of Education started finding violations of Title IX when previously they had mostly worked out resolution agreements with colleges and universities. And as a result of all of that, more and more students started to be expelled or suspended from colleges for sexual violence, at which point a new wave of litigation came into the field where accused students, and you'll hear from Justin on our panel about the implications of that, started to sue colleges and universities for due process, for negligence, a number of things, breach of contract, more than anything though, Title IX, to allege that their rights as men were violated in the haste with which colleges went to protect the rights of victims, primarily women, and therefore achieved an inequity in the system. So the perfect storm for me is that right now there are 8 new laws proposed before Congress that are going to attempt to regulate my field once the election is passed. And there are more than 170 lawsuits that have been filed by accused students that are working their way through the federal courts, almost an equal number of victims suing their colleges under Title IX as well, and college administrators who are trying their very best with very limited resources to navigate within this perfect storm. So I'm going to turn things over to my co-panelists at this point and let them describe what that storm is all about from their perspectives, and I'll join you again in a little bit.
And before we get actually started, I know we started about 20 minutes late because of the awards luncheon, so I'm going to assume that we probably will have a little bit of extra time and we'll go over. I see the nodding of the chair-elect, so I think I've got the authority. We are running behind schedules, but not our fault, and so this we'll have the full 90 minutes, hopefully.
Justin? Okay, so I've been asked to talk about what the typical case looks like on campus as I see it. So my firm is represented, can people hear me in the back, or should I use the mic? Mic, all right. I'm not as loud as my wife tells me I am. All right. So my firm has represented about more than 70 students at more than 50 schools across the country. So we've done it from, I think, Alaska to Florida and Maine to California. So this is a fairly broad spectrum. This isn't just sort of local DC stuff. Typical case, as I've seen it, it involves both people drinking and just sort of your average amount of college drinking. 2 people go out, they meet at a party, they go back, they have sex, and then later on a report is filed, sometimes the next day, but in my experience, on average, the average complaint takes about 3 months to file. The record for me is I had a case where the complainant waited 3 years to file the complaint. It happened freshman year, she filed senior year. And these are cases, in my opinion, in which what you have here is basically people who regret making bad choices and then want to use the disciplinary process to ratify that position. I can count on one hand the number of cases I've handled that have an allegation of force. And now realize, though, who I am, right? I mean, I'm at a law firm that charges a fair amount of money. And so, if you have your Brock Turner case, Brock Turner was not a campus sexual assault case. That was a rape case that happened to be on a campus. So, I'm sure I get a skewed view of what kind of cases there are out there, because that's the people that hire me. I only really get hired in the very, very gray cases where there's alcohol and things like that. So, what I often see is that you have a delayed report, and the complainant will, I think oftentimes the initial report is, and I'll use gendered language here because it's just easier, and frankly, these are typically gendered cases, although I have represented women complainants, and I even had transgender folks in the mix as we've done these cases. But I will, forgive me for shorthanding with gendered language. So what we'll have on average is some sort of alcohol-infused encounter. And then a lot of times what you'll see in terms of the witness statements or how the text messages back and forth between the parties go is, maybe there's regret and the young woman, wishes this hadn't happened, and then it'll sort of go on. And as I see it, what can often happen is they will go to the friends, and what becomes something that was initially something that they wish hadn't happened will over time, I believe in consultation with campus counseling centers, with friends, will sort of subtly transform into, well, I didn't want it and I didn't consent. And then you get these very gray cases where, again, in 90+% of my cases, nobody's alleging, the complainant's not alleging that she said no. It was just, I was too drunk, not passed out, not, falling down, just, in that very gray area between when are you sort of a happy drunk who is having happy, enjoyable drunken sex, which people have been doing since the beginning of time, and when are you crossing a line to where you can't validly consent. So that's really, in the cases that I handle, what I see the most. And I think it's what often happens in the hearings is that they become essentially about the line between intoxication and incapacitation. And before we started, I was talking to Brett, because the best policies that I've seen at schools will say intoxication is not, incapacitation is a state beyond mere drunkenness. And it will list a variety of factors. And it's a really good policy because it'll have things like slurring your words, falling down. And I asked Brett, Brett, can I just guess that you wrote this policy that I've seen at a dozen schools and more? And he said yes. And so that's the best policy, when you have something that someone like me can argue to a panel and say, look, they may have been drunk, they may have been drinking, but the question isn't, did you have drunken sex? The question is, was the complainant incapacitated? And frankly, I think schools that don't bring Brett in often do a very bad job of drawing that line, because it's very hard to define how drunk is too drunk. I mean, for the married folks among you, do you ever go out and celebrate your anniversary? You get some wine, some champagne. You come home, you have drunken sex. Surely, you're not waking up the next morning and telling each other you didn't consent. But that is honestly what a lot of these cases look like. And again, I want to qualify that. These are the ones that I'm handling. I'm not getting hired when the person's claiming they were passed out. I think that just typically goes criminal. Or maybe those people don't think I'm a good enough lawyer and don't hire me. So that's one thing, is the line between intoxication and incapacitation. The second thing is consent. How do you define consent? I was literally prepping a client this morning to be interviewed next week. And this school had an affirmative consent policy that says, consent must be active, either through words or actions. Now, most of the time, people don't use words, right? That's just not how we as human beings typically have sex. May I touch you there? May I touch you there? Can I do this? Can I do that? That's just not how most people have sex and engage in a sexual encounter. Usually, there's sort of a natural progression. One thing leads to another, and both people appear responsive. But if you try to break that down into its constituent parts, it gets very awkward very fast. What made you think that there was consent to intercourse? Well, I'm not going to get too graphic here, but we have been doing this, this, and this, and she was rubbing my back, and making favorable noises. And, it's very hard to define how you actually know that there was consent. And I think, again, just to sort of use a common sense, a lot of times people are left to say, I don't know, we both just seem to be enjoying it. So I think that's also what you see a lot of these hearings, is how can you tell what consent is? I think Andrew wanted me to address what do I see are sort of the biggest due process issues in these cases, and I use that term broadly because, of course, the due process clause does not apply at private schools. I think there are issues, lawyers can't talk at all in these processes during the hearing. Some schools, I've literally been told in meetings with my client, when the school's interviewing my client, that I can't even talk to my client in the meeting, which is, I think, a pretty outrageous violation of all the Title IX and its regulations. But that happens. You can't cross-examine the accuser. You can't call witness. A lot of times, schools will say you can't even interview witnesses. I've been at several schools that say it's a violation of our school policy for you to interview any witness who might have evidence in this case. I think sometimes you have biased investigators. I've often said, and forgive me for the Title IX coordinators in the room, no one in the history of the world who really cared about due process ever went to decide to be a Title IX coordinator. It just doesn't, that's just not the pool it draws from. It's not to say that they can't care about that, but that's people who are passionate about due process and legal procedure and defense work or fair trials typically don't choose that as what they want to do with their lives. And I think that's problematic. And then I think you have very problematic training materials that are often used at these schools, both to train the people who investigate and to train the people making the decisions. And because it's always good to have an example, I will read. These are training materials from a school that I won't name. And these training materials, they were given not to the investigators. They were given to the jury. They were given to the panel of people who were charged with deciding guilt or innocence. And we happened to get them through other means, but they were not disclosed to either of the parties before the hearing. And I'll just read two things of the panel. Number 14, there are a lot of points. Number 14, and this is told to the jury. False allegations of rape are not common. One myth is that out of revenge or other motives, women make numerous false allegations of sexual assault. Recent research at a major Northeastern university suggests that over a 10-year period, 5.9% of its cases involve false allegations. Other reputable research places the rate in the general population between 2% and 10%. So what you are doing at that school is you are telling people who have to decide by 51% whether someone committed sexual assault that there is between a 92 and 98% chance that the complainant is telling the truth. I assume all of you in this room are lawyers. I defy you to defend that as a matter of basic fairness. But yet that is what so many people are being told, so many people who are on these juries are being told. And then another good one is the typical respondent is neither a brutal stranger nor a good guy who has had a bit too much to drink one night. Rather, he knows his complainants, premeditates, and uses little overt violence. That is a load of bull hockey. That is absolutely ridiculous. Knows his complainants, premeditates. I mean, I have literally never, and again, maybe I don't get hired for those cases, and I'm sure those people exist. But the idea that you are going to give the jury, a jury instruction, essentially, that says, these aren't good guys, these are premeditating people who groom their complainants, that is outrageous. And I hope, regardless of what side of these issues you're on, you would agree that someone deciding guilt or innocence should not be told there's a 92 to 98% chance that someone's telling the truth, or that the person who's being accused may seem like a good guy, but in fact, he's just a grooming rapist. So those are the issues as I see them. And again, I have a narrow slice of this, but that's my take on these things.
Justin, before we get to Colby, just real quick, what is, in your experience, the remedy for violating, say, the school policy? So, say, for example, you're representing an accused where the school policy is that you are not allowed to interview witnesses, and let's suppose that you hire an investigator to interview the witnesses anyway. What remedy or what are the sanctions for violating that school policy?
Sure, I actually can give an example. The school will independently sanction you for doing that. If you mean the remedy? What is the remedy of the school against the complainant?
Yeah.
Against the accused student?
What are the consequences?
Well, the consequences. Yeah, I mean, I had a case that I advised on. I wasn't the main the main attorney that was out in the Midwest. And the student there had a very aggressive criminal defense attorney, I thought, who frankly was an extraordinarily good criminal defense attorney, but didn't have the nuance to do the campus cases that aren't really criminal processes. And there, the student actually won the case, was found not responsible for the sexual assault, but was later brought up on charges that the investigator had been too aggressive in pursuing evidence that the complainant was not telling the truth, and he was charged with retaliation and found responsible. And again, in sort of interesting things to think about, how, if he is later asked to describe what he was found responsible for, can he do that without telling the questioner that he was accused of sexual assault? You can get charged with retaliation or just with a violation of the process.
So the penalty applies to the student, is typically the sanction, is against the accused.
Correct, and usually most schools will not tell complainants. It's often, frankly, one-sided, because frankly, if you just think of how these things often play out, if someone did not sexually assault someone, if someone believes that it was a consensual encounter, that person is unlikely to go back to their dorm that night and say, I just had consensual sex with XYZ, and it was definitely, she was not incapacitated, and let me tell you all the details. Whereas a lot of times the complainants, if they are having mixed feelings about the encounter, will immediately go start to telling other people. So they already kind of have their witnesses, and we're not allowed to talk to them. So, and the schools do enforce those. They do enforce them, and frankly, I don't want to test them. I mean, if I'm told, I'll write a letter to the GC or to the outside counsel. But if I'm told no, hard no, you are not allowed to question witnesses, I'm not going to do that. That would be stupid, because then they could just punish my client for it.